The Criminal Procedure Identification Bill 2002 has been passed this week from both the Lok Sabha and the Rajya Sabha, and it intends to widen the scope of the information about a person that can be collected by the police or any investigating authority when trying to figure out if a crime is committed. Now, its origins are from a bill or an existing law from 1920, which actually allows police officers to take photographs, details, fingerprints, etc. of any accused or any convicted criminals. This particular bill hopes to widen that ambit because the purpose of it allegedly is technology has changed, right? So now you have to go beyond this. You have to get biometrics, iris scan, maybe the kind of information which can identify your DNA as well. So blood samples, etc. Now, this bill was passed amidst quite a bit of controversy, and part of it was because some activists believe that this could be a tool in the hands of lawmakers or of officers to violate the privacy of individual citizens. Why is that the case? That's what we're trying to understand on the show today. From the government's point of view, it is a necessary tool that investigative officers need. Our conviction rates are pretty low, and they need to have details which could give evidence in a court of law to show that X has committed a crime that he or she has been accused of. But on the other side, does this bill give too much power in the hands of investigating officers? Before we start the debate, let me just play out for you what Home Minister Amit Shah said in defense of the bill in Parliament when it was being discussed.
हमारे पास क्रिमिनल का डेटा नहीं है, वो क्रिमिनल का डेटा इसके अंदर ऐड होने से इन्वेस्टिगेशन और प्रोसिक्यूशन बहुत सरल हो जाएगा। और क्या भय है, किस चीज का भय है? मान्यवर, I4C के माध्यम से ढेर सारे और भी अलग अलग सेवाएं ली हैं और 112 के माध्यम से सभी पुलिस सेवाओं को एक ही फोन नंबर पर लाने का काम भी भारत सरकार ने मोदी जी के नेतृत्व में किया है। मान्यवर, मैं इसलिए बताना चाहता था कि ये जो हमें जिस तरह से कटघरे में खड़े करने का प्रयास हो रहा था कि इसके पीछे कोई राजनीतिक उद्देश्य नहीं है, ना जनता के मन में भी ऐसी भावना जानी चाहिए, ना सदन के सदस्यों के मन में भी ऐसी भावना चाहिए। हमें भी मालूम है ये जो लोकतंत्र के अंदर कुर्सी होती है ना, ये यावत चंद्र दिवाकरों नहीं होती है, कल कोई भी आ सकता है। तो मिसयूज का भय तो मुझे भी लग सकता है, मगर मुझे नहीं लगता है मिसयूज होगा तो देश की अदालतें हैं।
To speak more on this, I'm joined now by Apar Gupta, advocate and executive director at IFF, and Shreya Rastogi, who's head of forensics project 39A at the National Law University, Delhi, who's been studying the subject in some great detail. Let me come to you first, Shreya, and try and understand where the concerns emerge from. This is now a bill that has been passed in both houses, will be notified presumably soon and come into law. On the face of it, it seems perfectly logical that in this day and age of technology, why should investigating officers not be able to collect more evidence than just a photograph, for example, of someone who could have committed a heinous crime? Why do you think there's a problem with that?
Thanks, Tamanna. So, first of all, I'd like to clarify that actually the investigating agencies for years now have been collecting the kind of measurements that are covered within this bill for investigative purposes. Our law already allows for that. The only difference is that the law currently requires that if you're collecting such information from an arrestee, then there needs to be reasonable grounds as to how such information is going to afford evidence towards that person's participation in the bill. This bill, however, in the offense, but this bill, however, takes that requirement away. It expands the scope of what can be collected from an individual. That person can be an arrestee, a convicted offender, a detainee, or any person who the investigating authorities believe whose measurements might actually be expedient, which is to say that, could be convenient or useful for investigation. So actually, the scope of the bill widens this to any person, and the authorities don't have to show whether you are in fact in any way connected to an investigation that's going on. The second reason why I think the bill raises many concerns is actually in its own technological premise. The bill believes that these measurements are somehow unique to individuals, and the forensic techniques that we use towards analyzing these measurements do not have any errors. And both of these assumptions are in fact incorrect. Science is telling us that many of these measurements are actually common with individuals, and so therefore what the bill states in its objects.
Let me just understand that for a second, Shreya, if I may, and just give me a minute. Apar, of course, I'll come to you. So are you saying that fingerprints are not unique? I mean, wouldn't they identify a person? Wouldn't any samples like saliva or blood help in identifying exactly who that person is? And wouldn't that help then determine in particular cases, of course, depending on the crime, whether that person has committed it or not?
Yes, that's exactly what I'm saying. Because if you look at the scientific evidence, and in fact, we need to turn to the advanced countries that the bill refers to, because that's where most of the foundational research in scientific validity on these techniques is happening. And if you look at, for instance, the AAAS report that came out in 2017, which clearly states that there is no scientific evidence to prove that fingerprints are unique to individuals, right? So that doesn't mean to say, I mean, by looking at that evidence, I don't mean to say that do not use forensic evidence or fingerprint evidence particularly in any case. However, it does not explain why you need to expand the scope of it, of collecting that evidence from all individuals, and also towards databasing that and creating such vast databases. And similar concerns about uniqueness, in fact, exist for other areas as well. Some of these areas, for instance, footprints, iris scans, retinal scans, they have not even been investigated into scientifically to understand what is the uniqueness behind them.
So since I know that you and Apar both have concerns, I want to play devil's advocate here on this discussion to take it further. Apar, now the argument is that a lot of countries around the world do this, developed nations do this. Some of the best investigating teams and forensic teams in the Western world use all of these tools, and it helps improve their conviction rates. It helps reduce crime. Why should those tools not be available to Indian investigating agencies?
So the one thing I'd like to just underscore is that what Shreya is also saying is that it is not as if the Identification of Prisoners Act 1920 did not need to be updated. So I join with a lot of people who say that the advances in technology need to be reflected in lawmaking, but they need to be reflected in the measure the science actually is dispositive, because the criminal sanction is very immediate. It's very extreme. So you need to be moderate in what you do. And if you're relying on science, then you need to account for science as science. The second point we are saying is that when you're updating the bill as per scientific techniques, and this is a law, you will also update it from 1920 to 2022, 102 years, as the Home Minister stated, not only as per scientific advance, but also as per legal advance and human rights advance. In those times, women did not have universal franchise, for instance, right? We have discovered our errors as a society through time. And one thing we have discovered is that there are certain protections for people which flow from the doctrine of privacy, given that data sometimes can result in profiling. This comes through two specific measures of protection. One is the right against self-incrimination, where certain information can be contextually gathered or people can coerce to confess against themselves. And the Supreme Court in 2010, in Selvi's case, says that this is not permissible, it offends constitutionality. The second is the Puttaswamy judgment, which is on the right to privacy and says that you can't conduct mass surveillance in order to catch thieves in a society, right? Or offenders in a society. So when you update the science, do it in a way which actually reflects the state of the science. And secondly, the advance in science cannot be unilateral to our constitutional protections and needs to step with it. Hence, Where I think the government has committed an error is with the haste it's approached this entire thing by updating a 102-year-old law in possibly 4 days of session of parliament rather than sending it to a standing committee for scrutiny.
Right? So that is a complaint we have seen with a number of controversial bills, that did it go through due process, etc. And that, could be a wider point of debate. But I want to stick to this particular bill and what is concerning. Now, when we hear things like there could be a violation of privacy, of individual rights, it's in large abstract, comments. Shreya, can you give us a for example? What could happen here which you think is concerning? Because logic would dictate, if your fingerprints are taken where you could be, or any of your data, biometrics, etc. are taken because you could be a suspect, once the investigations are complete, the data would prove that you're not. It comes out of that central database and you're done with it. At least that's what the intent of the law says. So give us a for example why you think this could go wrong.
Right. So if you look at clause 5 of the bill, like I mentioned before, it covers any person that the investigating officer believes whose measurements might be expedient in investigation, right? So they can make an application to the magistrate can order this. So imagine a situation where the police is unable to solve a crime. This crime has happened, for instance, in Dwarka in New Delhi, and they've tried everything possible. They're not able to solve this. The final measure that the police could actually take is go to the magistrate and say that, let me collect the DNA evidence of the millions of people living in Dwarka because I'm unable to solve this crime. You will actually allow such a dragnet because the bar is so low, because the bar only calls for expediency. This DNA, which is collected then from all of these individuals, in fact, by clause 6 of this bill, it can be compelled on them, so they need not even consent to collection of such material. It may then be analyzed. It can then, under clause 4, be database, and clause 4 doesn't even allow deletion of the material from such persons. So their data can remain in these vast forensic databases, which will be run by NCRB as well as by state and union territory administrations. We don't know who, at what level this will actually be maintained, whether this will be at a district level, at a state level, at a regional level, who's going to monitor this data, whether there will be any quality assessment, who this data can be shared with, even that is elusive. So that is the level of the problem that we're dealing with here, that your measurements, if the authorities believe it should be collected, it can be collected. You need not have any kind of relationship with that investigation. The authorities aren't even required to show that.
And if you resist for certain sections or certain kinds of crimes, if you resist giving your data, then that would also be a criminal offense. So tell me, Apar, what is the problem with that data being there for 75 years? Which will go away if you are found unconnected or unconvicted, or the trial ends, etc. What are the concerns of what could happen with that data?
So the first problem is basically the acquittal by itself presumes that the acquittal in India happens as of course, and there's no delay in adjudication. So the thing is that the purpose for which these measurements, this vast trove of data is being gathered is for the case. But no, that's not the case when you read the law. Because the law is saying that the measurements are stored centrally, and this is a word. It's used for prevention of offenses. Okay, now you may say that, oh, well, this may only happen to hardened criminals or under trials, people who commit crimes habitually. No, that's not the case. Because the bar, as Shreya explained, which was earlier, that you need to be accused or under trial or convicted of offense more than 1 year, is not longer there. So the expansion is you preserve that data for long periods of time, not only connected to that specific crime which is being prosecuted by a court, which is taking a large number of years, but even presuming you are acquitted by that court, the transmission of that order by itself may not result in the deletion, because as Shreya again explained, that data can be shared by the central authority with other agencies. So mirror copies will still exist, and we don't have a data protection authority.
No, but Apar, the people watching this will ask, so what if the data is there? If you've done nothing wrong, you're fine. And this is part of what the debate was in Parliament. where,
So I would,
one MP
yeah,
stood up and said that, my data, I will be targeted, and the member of parliament was told, but, it's the only people who need to worry are criminals and terrorists. So I put that question to you, Apar.
So the thing is that the bar is so low. I just like to say to people, do they really have very pleasant civil conversations with people who are enforcing the law in the police services? And I would say no, because the thing is, quite often when we are not wearing a mask, we may be breaking a law, we may be in an inconvenient situation, we may be jaywalking across a road because traffic is not stopping, there are no pedestrian walkways, or we may be strolling in a park after 8 p.m. because we may not be feeling. Those are all offenses for with the application of this law and the storage and taking of your measurements. So it will not only apply to the people who we consider as criminals. I think most people do not realize how often they break a law, but they're insulated by the privileged position and the ability to navigate the law. But that will not remain if this law starts being applied in its full measure and force as permitting the police to do that. So I would just like to say that the earlier law, the 1920 law, the colonial law made by the British had better safeguards for people like us who we consider not as criminals compared to this law, under which there's a universalization of how any persons can be stopped and their measurements can be taken. So more or less, Tamanna, I would say it's a moot point that when people say that I have nothing to hide, my data won't reveal anything. For instance, I think people are not being completely honest with themselves with respect to their daily activities. They in fact are presuming they can get away with it, or they consider their acts not illegal by itself. And the law as it applies, one final thing I'd like to add, how state governments using this data. So, and I'm using only the examples of Rajasthan and Punjab, state governments. Rajasthan has stated it has an app called Rajcop application, which use analytics capabilities in real time with multiple data sources and pools it together from different databases. Punjab similarly has an artificial intelligence system using machine learning, deep learning, virtual search. So imagine even if your data is just there, they've gathered it, but they end up coming to your place again and again and asking you, are you breaking a law? And that kind of petty harassment has happened to many people in their personal experience.
Okay, so petty harassment is the real concern. Shreya, what are the safeguards you would have preferred to see? Because, I mean, the fact is that technology has moved leaps and bounds. The AI technology that Apar is talking about, companies are using it to target and figure out what to sell you. So all of this technology is out there. The only question is, why should one section of society, and in this case, the keepers of law, however good or bad or whatever they are, why should they not have access to it, right? So in that case, what are the kind of safeguards you would like to see, which would make you feel that, yes, we have to move with the times, but at least we have a safety net?
Right. So, like I said, we are already allowed to do everything that this law covers, both under the old 1920 Act as well as under the Code of Criminal Procedure, Section 53, that allows for collection of a wide range of biological samples that would be covered here. Right. And all kinds of analysis is already allowed. What I would have wanted to see is if there is a requirement to expand the scope of what we are collecting and whom we are collecting from, then at least the reason why we're collecting this measurement, right, and how we will use this measurement, that should be specified in the law. Right now, the law is ambiguous insofar as we are assuming that this measurement itself and the forensic analysis on that measurement is going to be the evidence in and of itself. However, I'd just like to point out that the way the law is constructed, it can be used to mean that the measurement might be a way to obtain evidence and may not be the evidence in and of itself. So anything that you have locked behind a biometric, either in a digital space or in a physical space, even that can be accessed if I have access to your biometric, which I collect here. Secondly, whether this biometric is necessary for me to determine whether you are involved in an offense or not, even that is missing from clause 5. And thirdly, under clause 4, we are right now reading it to mean that if you are discharged or acquitted, then you can make an application and your data will be deleted. But as we know that clause 5 of the bill actually allows for collection irrespective of whether you are considered as a person of interest or suspect. So how will those people be able to get their data out? Even that isn't there. And who can I share the data with? no purpose for that sharing is included in the bill either.
So a lot of questions here, even as this bill has been passed, we'll have to follow its next steps to actual implementation to see how it goes. But for now, thank you so much, Shreya and Apar, for joining us and really explaining what those concerns are.
Thank you so much.